If you're a senior struggling with debt or money issues, it's hard to enjoy your life. But there are certain things you should know that can help you deal with your financial difficulties. Hi, I'm Jeff Hoyt, Editor-in-Chief of SeniorLiving.Org. In this video, Attorney Eric Olsen, Executive Director of the Helps nonprofit law firm, will tell low-income seniors the 4 things they should know that can help them turn their difficult financial situations around. Believe it or not, your income is protected, your bank account is protected, your assets are protected against virtually all lawsuits, and it's easy to stop debt collectors from bothering you. The former bankruptcy attorney will explain all these important financial concepts that could benefit you, as well as how Eric's law firm could help you at no charge. Because I'm in Los Angeles and Eric is in Portland, we will be conducting the interview via Zoom. Hi, it's Jeff Hoyt, Editor-in-Chief of SeniorLiving.Org. And once again, I have the pleasure of speaking with Attorney Eric Olsen. Eric is the founder and executive director of the Helps nonprofit law firm, which helps seniors and other people who are struggling with debt. Welcome, Eric.
Good to be here, Jeff.
So we have lots of seniors struggling with money and who are in debt. Any idea how many seniors there are in this category?
Well, okay, the Census Bureau says there's more than 50 million seniors that are over the age of 65. And 13% of those are over 65 or under the poverty level, okay? And it's more in some states than others, obviously. And then there's another factor. The Economic Policy Institute did a report, and they have what's called classifying someone as being economically vulnerable. And what that is, if you have income within 200% of the poverty line, you're classified as economically vulnerable. And 48% of seniors over 65 are classified as economically vulnerable. And the number goes higher as they get older. And so, if there's 50 million seniors, that's nearly 25 million seniors that are classified as economically vulnerable. So there's a lot of seniors that face financial problems. A lot.
So for these millions of seniors facing financial problems, as you put it, what's the number one thing that they should know that they may not know today?
The number one thing they should understand is that federal law protects their Social Security income. It can't be garnished or taken from them by a consumer collector, by a debt collector. It's protected. If I have 50 seniors in the room, maybe 49 out of 50 don't really understand that fact, that their Social Security is protected. Now, additionally, a lot of seniors get a pension, some form of retirement. There was a law passed in 1974 called the Employment Retirement Security Act, or it's called ERISA. And what it did is it said if pensions were set up in a certain way, that money would be protected and from debt collectors. So virtually all pensions today, all forms of retirement, IRAs, 401ks, that money is protected under ERISA. It can't be garnished or taken from a senior, protected automatically. Now, in addition to that, federal law protects veteran benefits, and then there's state laws that protect disability income and also doubles and protects some of this income also. But the federal law is what's important. So virtually all forms of seniors' retirement income is protected from debt collectors. And I guess that's our most important message that we want them to know, that if you're struggling and you have a lot of debt, you don't need to use that money to pay debt you can't afford to pay. Congress protected that money for a reason. They didn't want seniors to go without medicine, to go without food, to pay debt they couldn't afford to pay. So that's our most important message, is this income is protected.
And your law firm also works with veterans. Are VA benefits protected as well?
They absolutely are. Under federal law, VA benefits are protected.
Are there any exceptions?
Well, there's a few. The IRS can do what's called a set-off of 15% of a person's Social Security for past due income taxes. We don't see the IRS typically trying to set off pensions or other forms of retirement fund. We don't, they theoretically can, but we don't see it happening. Most of the seniors we work with are middle income or lower income seniors. IRS does not. The only thing they would do is they would send a notice that they intend to offset 15% of a person's Social Security. However, if a senior is lower income, okay, there's half of seniors that are within 200% of the poverty line, they should be able to qualify for what's called non-collectible now status and not have to pay the IRS these taxes. And that's not that difficult to do. We tell people how to do that. You can get on the phone with the IRS, wait 2 hours, go over the budget, and you can qualify for non-collectible now status, so you don't have to pay the IRS. Now, the same with student loans. Student loans, okay, there's two types, private and public. Public student loans, federally insured student loans, can do a set-off of 15% of Social Security. Now, they're not allowed to do it right now because of COVID and some other rules. But if a person has student loans and they're lower income, they can get on what's called an income-based repayment plan. And often that payment would be $0 per month. Now, if they're disabled, get the student loans wiped out. Now, after that, about the only way you're going to have your Social Security taken is if you owe past due child support. We rarely see that as the case, and that gets kind of complicated. But so if you owe student loans or taxes and you're lower income, shouldn't have to have your Social Security taken. It's protected. In addition, it's protected from all these other creditors as well.
So a lot of income for seniors appears to be protected by federal law and state laws. Is there anything else that these laws protect for seniors?
Their bank account is protected. Federal law protects a bank account. I'll explain, okay? There used to be a big problem with seniors would get sued and someone would garnish their bank account. And even though that the money in the account was from a protected source. And it was a big problem. So back in about 2012, Congress had federal rules implemented. And what these federal rules provide is that twice the amount of federal benefits, and that's Social Security, most federal pensions, that amount of money that's deposited into a bank account, twice that monthly sum is automatically protected from garnishment by federal banking regulations. So if a senior got like $1,500 in Social Security each month, and it's deposited into a checking account, and that means that $3,000 in that account is protected automatically, regardless of what monies are in the account at the time of a garnishment. Okay, so if the person had money in there from something they sold on eBay, or maybe they want a little lottery ticket or a little gift, as long as there's less than twice the amount of the federal benefit in the account, the bank account is protected. Now, how does that happen? The bank itself protects that money. The bank or credit union has a department that governs, that handles garnishments, and they know the rules. And so if there's a garnishment on a person's bank account, they look at the bank account, and there's a code that tells them where the money came from. And if it came from a federal source, they times that times 2. And as long as the balance in that account is less than that sum, then they simply rip up the garnishment, they ignore it, they throw it away. Now, if a senior had more than twice the amount in that account, it's a senior that came from a protected source. A senior could file a challenge of garnishment or a claim of exemption with the court to have the money released. But most of the time when I talk to seniors, they'll tell me, well, Eric, I never have more than twice the amount of my Social Security in that checking account. And then I tell them, well, you don't need to worry. So if they call and and there is a judgment or there's a threat of a judgment, and they have more than one bank account, I would tell them, you really only need one bank account, and that's the account into which your Social Security is deposited, and it's twice that amount is protected. Now, something seniors should understand that the bank manager probably doesn't understand that law. They don't, because they have nothing to do with garnishments. I'm guessing that 99.9% of attorneys don't understand that law. You see, for years there was a different rule. It talked about if monies were commingled, it could be taken. But there were so many problems with that Congress saw that federal rules changed it to automatically protect bank accounts in which Social Security was deposited, regardless of the source of funds in the bank account at the actual time of a garnishment. And that's been a wonderful change in the law, because a lot less headaches for seniors nowadays because of that rule.
But only if they know about it, thanks to people like you.
They should know about it because they want to be careful if there's a judgment that they keep less than twice the amount of the federal benefit in the bank account, so that if they were garnished, nothing would be taken out of their account. It's unlike they're going to be garnished anyway, but it could happen. But this way, it's insurance. They don't need to worry.
And do they need to worry about their other property, like a car or a home or anything else? If their bank account's protected, could a creditor go after their property?
Yeah, so their bank accounts are protected. And then so a lot of times seniors might worry about, well, are they going to take my car? Or are they going to lose my home? Someone going to come in and take my furniture or things like that. Okay, the answer is essentially no. I mean, and I'm going to explain why. Okay, first off, virtually all states have what are called exemption laws that exempt certain types of property. Exemption laws that will protect an amount of equity in a home, or an amount of equity in a car, or it will exempt, certain amounts of personal property. A lot of states, most states have what's called a wild card exemption, which says that if this isn't covered by our exemption, you have a certain amount of money, like maybe you have $4,000 that will cover everything else. So the rules get kind of complex, and most of the time these rules are used when if a person filed bankruptcy. A bankruptcy trustee will look at that to see if the property is exempt. But as a practical matter, if a senior got sued and got a judgment, even if they own property that was over above the state exemption, it's really not the practice of consumer judgment creditors, especially credit cards or bank loans or anything like that, to go after a person's property if it was not exempt. There's a lot of reasons for that. It's a complicated process. They have to get a court to authorize it, and a lot of times they have to put up a bond. And as a practical matter, personal property, your furniture and all this other stuff, isn't worth a whole lot of money, even if it's over the exemption. And they've learned by a school of hard knocks that it wouldn't work. And then there's ways to, if it were to happen, there's ways that it could be stopped. So seniors losing their personal property, it's just not going to happen. It just doesn't happen. Now, if a senior was sued and there was a judgment and they owned a home, okay, the judgment can become a lien on the home in certain states. And so let's assume that the senior had equity in that home over and above the homestead exemption for that state. Will that creditor come in and try to take the senior's home? Well, a lot of people might try to scare a senior into thinking that that's a possibility. But once again, as a practical matter, no, it doesn't happen. Consumer judgment creditors get the judgment and they're happy to let it sit there and hope that they get paid when the home is sold or refinance or at some point in the future. But they won't take steps to try to take the person's home. And there's a lot of reasons why. First off, they'd have to pay off an existing mortgage, and they're not in the business to do that. Okay, that might be a lot of money. Number two, they'd have to pay the homestead exemption, and then they have to pay an attorney, go through all that paperwork. And it's just not worth it to them. Now, the only time I've ever seen this happen is if you have a particularly vindictive creditor, a relative or someone like that, and it's really clear that there's a lot of equity in there. But as a practical matter, that is so rare, and things could be done even at that point to solve the problem. But no, they don't need to worry about their property being taken. I mean, some debt collectors will try to use, in certain states, will try to use certain state authorities to intimidate a senior into thinking that it's going to happen. That's Utah was one state, Texas also. They have like constables in Utah, and in Texas they have these little local courts that will send a letter out, and they'll think, oh my gosh, we're going to lose our property. Well, no, like in Texas, there's a $50,000 exemption that goes over all your personal property, and there's no way on earth that a senior would have that amount of equity in their personal property. So no, they don't need to worry about losing their property. It's just not going to happen.
Good to know. So you mentioned debt collectors, and even if they can't get a judgment or collect a judgment against a senior, debt collectors can still call you and harass you. Is there anything seniors can do to protect themselves from debt collector harassment?
Absolutely, or anyone for that matter too. And I guess that's another thing that seniors need to know. So if they know that their income is protected, okay, and they know their bank accounts are protected, and they know that no one's going to take their personal property, and if they say, I'm not going to pay my debt, but it's not very fun to have the creditors call you. It can make life miserable, or even file a lawsuit. Okay, and think, oh my gosh, so it can be very scary. Okay, so back in '74, there was a law passed. It's called the Fair Debt Collection Practices Act, FDCPA, and that sets out the rules that collectors have to follow in trying to collect debt. They can't call before or after a certain time. They can't threaten that they're going to do something that they don't intend to do, or they can't. They can't swear or cuss. They can't say illegal things. I mean, there's a lot of rules. But one of the most important part of that Fair Debt Collection Practices Act, that it provides that if a debtor, in this case a senior debtor, sends what's called a cease and desist letter to a debt collector, that debt collector can no longer legally call that person or send a demand letter or send letters to that person anymore. Okay, and that needs to be sent. It has to be in writing and sent to the debt collector. And I call them commandments, and I say one of the major commandments under this rule is that if a debt collector gets a cease and desist letter, they know they can no longer call this senior anymore or send him demand letters. They got to leave him alone. And the law also provides that if a senior is represented by an attorney, then the debt collector can no longer call or send demand letters to that person anymore. Now, this law applies to debt collectors, not an original creditor. So technically, if a person had a credit card and they were current on it, that law doesn't apply to an original creditor, but sometimes there's state laws that provide for that. Even when an original creditor gets what's called a cease and desist letter, they normally honor it. They may continue to send a bill, but yeah, seniors don't have to be bothered by debt collectors anymore. They can be protected, and the law provides for that. And that's what we do. It helps.
If a senior's struggling with debt and can't pay their bills, how can they afford a lawyer like you?
So I probably did 30, 40,000 bankruptcies before I started Helps a little over 10 years ago. And I saw there was a lot of seniors that, their income was protected. They didn't need to pay this debt. They were lower income or poor. They couldn't afford a bankruptcy. And I knew that they could send out a cease and desist letter, but that's kind of hard for a senior to do. And then they got a lot of questions on top of that. And so Helps was founded to represent lower income and poor seniors who have debt they can't afford to pay as their attorney, so they don't have to deal with debt collectors. And the only way I knew it worked, we'd have to be what's called a 501c, which would be a charitable organization. So what that means is that about 1 out of 4, 1 out of 5 of our clients get our help for free. Okay, they don't have to pay anything. We never turn anyone away that needs our help. But for a lot of seniors that have income, we charge a very modest fee. An example would be $20 a month for 12 months, then $10 a month. It might be $30 a month for 12 months, then $10 a month. But it's not very much. And then they contact us. We can enroll them in our program literally over the phone in just a few minutes. And click a button and they'll get an email from us confirming they're a member of Helps. And then they give us the people they don't want to hear from. Within 24 hours, we send out what's called a cease and desist letter to their collectors, telling them that this person can't afford to pay them anymore. Don't bother them. If you have any questions, contact us at Helps. So that's what we do. We represent seniors and disabled persons who have debt they can't afford to pay as their attorney, so they have to deal with debt collectors. But people can do this on their own. But I talk to a lot of seniors; they don't want to do it on their own. So that's the way it works. And in order for this to work, the representation has to be ongoing, because a lot of times debt collectors will sell the account to a new collector. So if they can't collect, they're going to sell it to Joe down the road. And so senior might get a letter 6 months, a year, 2 years down the road from a new debt collector. When that happens, the senior just calls us on the phone or lets us know, and we'll send out a cease and desist letter to that new debt collector. In the meantime, if they're ever called, they refer them to Helps. They say, hey, I'm represented by a Helps nonprofit law firm. You cannot legally call me anymore, and you hang up. So that's what we do. And what we're here for is to, answer the questions, assure them, provide legal information so they know their rights. A debt collector will never tell a senior their income's protected, never. And they're happy to sue them. And a senior file a lawsuit hoping that the senior will be intimidated to try to pay them, when in fact the senior doesn't have to pay them, because their income's protected, they're safe, and their assets are protected.
So if someone did want to avail themselves of your services, how would they contact Helps?
Our website, www.helpsishere.org, HELPSISHERE. HELP stands for Help Eliminate Legal Problems for Seniors, okay, and disabled persons. And then our phone number is 855-HELPS, HELPS, US, Helps Us or Helps US. And then call us on the phone, visit our website. We can spend hours on our website. We have lots of articles, and we have a YouTube page too. And we're there to answer questions and provide information. Our second purpose, Jeff, is to educate seniors, especially lower income seniors and poor seniors, how they can maintain their financial independence, because that's what it boils down to. The seniors have this limited amount of money. They need to protect it so that they can be independent financially. If they think they have to use all their money to pay their bills and they have a ton of debt, then it's extremely distressful, and it doesn't need to be that way.
Well, I think you've educated a lot of seniors today. Thank you very much for your time.
Thanks for having me, Jeff. I really do appreciate it.